All right. Hello, everyone. I'm Tanner Cook. I'm an attorney in Husch Blackwell's False Claims Act group, and I want to welcome you to today's webinar. Before we begin, I'm going to cover a few housekeeping items. First, at the top of your audience console, there are multiple applications for you to use during the program today. For example, if you have any questions during the webcast, you can submit them via the question box. We will try to answer your questions during the webcast today, but if a fuller answer is needed or if we run out of time, we promise we'll answer your question later via email. Also, if you'd like a PDF of this presentation, there's one available for you in the program materials folder at the top of your screen. This program has also been approved for legal education hours. So for live attendees, you can report your hours by clicking on the continuing education sign-in link at the top of your screen. A certificate of attendance, including course numbers, will then be emailed to you tomorrow, along with a recording of the webcast. Lastly, we do have a short survey we'd like you to complete at the end of the program. We really value feedback, and we use it to help plan future programs that are applicable to your business needs. And we're also just generally interested in your thoughts on the information we provide. So please do fill out that survey if you have a chance. And that's all for the housekeeping matters. So with that, let's get started with our program. Joining me today is my friend and colleague, Abraham Souza. Abe is also an attorney in our False Claims Act group and is a seasoned litigator and investigator who guides clients through complex disputes, enforcement actions, and high-stakes trials across all industries. So without any additional delay, I'm going to turn it over to Abe to get things started for us.
Thanks so much, Tanner, and welcome everyone to our presentation today. We're looking forward to a great discussion. This year has been a bit of a whirlwind in terms of everything going on in the False Claims Act, or FCA space, and we thought it would be a great time to take stock of where we are and where we're headed in this critical practice area. So thanks so much for joining us today. In terms of today's agenda items, we'd like to cover 2 or 3 topics, depending on how you characterize them. The first one is the new administration's approach to FCA enforcement. This is a topic that's near and dear to my heart, and more importantly, my practice area. I joined Husch Blackwell at the end of last year after coming over from the U.S. Attorney's Office in Chicago. And while I was in AUSA, I worked on civil enforcement matters, including under the False Claims Act. And we're only about 6 months or so into the new administration, but there's a lot that we can learn and glean about its enforcement priorities based on what has transpired so far. So we're going to take a dive into that. We're also going to be covering recent Supreme Court jurisprudence and developing case law and other critical developments in the law, including challenges to the constitutionality of the FCA's key TAM provisions. So lots to get through here. We'll be moving quickly, but not too quickly, and we'll try to get you the details you need. And with that, let's go ahead and get started. So before we get into the new administration's approach to FCA enforcement, we wanted to start with the False Claims Act statistics for fiscal year 2024. And in that way, we can kind of look backwards to look forward and understand where the new administration came in and what the state of play was. So these statistics covered fiscal year 2024, which ran from October 1, 2023 through September 30, 2024. So they do capture the past and not exactly the most immediate past, but they're typically issued in February. They were issued a little bit early this year, right in mid-January, seemingly to get the statistics out before the inauguration, given the change in administration. And what the statistics showed is really interesting. So first of all, settlements and judgments exceeded $2.9 billion. That is a slight increase over fiscal year 2023, but continuing to trend lower than the pre-pandemic time period. Healthcare made up a significant chunk of that 2.9 billion, coming in at 1.67 billion. The number of healthcare FCA cases remained stable as compared to prior years, but associated recoveries, and in fact, that $1.67 billion figure is slightly down from prior years. What we've seen is healthcare has become an increasingly smaller share of FCA recoveries, despite the fact that it still makes up a significant number. The big takeaway, though, for a lot of practitioners in this space is that even though settlements and judgments remained relatively static, fiscal year 2024 saw the highest number of key TAM lawsuits ever, 979. And the consensus seems to be, myself included, that the spike relates to, at least in part, pandemic fraud cases. These would be PPP loan fraud cases, economic injury disaster loan or EIDL fraud cases. Many of these are brought by data miners based on their analysis of publicly available information, and they raise very interesting questions about whether these cases are barred by the public disclosure bar under the False Claims Act. Along those lines, there have actually been a number of DOJ settlements this year in these types of pandemic fraud cases where DOJ intervened and thus scuttled the litigation of the public disclosure issue. So it's a very, very interesting space. But those are the statistics, and this is where the new administration came in. So let's get into the new administration a little bit. One thing we want to highlight today is the apparent tension between efforts by the new administration in some sectors to cut back on the size of government, to decrease regulation, to decrease certain enforcement action on the one hand, with continued robust enforcement of the False Claims Act on the other hand. And that's one of the big reasons why we wanted to do this presentation, given the new administration's willingness to continue to focus on this area. And in some ways, it makes perfect sense. The FCA has long been a bipartisan endeavor, dating all the way back to the late 1980s when it was reworked by Senator Grassley and others. Attorney General Bondi, she has reiterated her commitment to the False Claims Act, starting with her confirmation hearing. And one of the first opportunities we got to hear about the administration's commitment to the FCA outside of General Bondi's hearing was at the Federal Bar Association's annual QTAM section conference in February in Washington, D.C. A lot of members of our team attended that. And the keynote was from Deputy Assistant Attorney General Michael Granston, who's a little bit of a legend at the department. He actually is no longer at the department, and we'll get into that a little bit later. But he highlighted from the start that FCA enforcement remains a permanent fixture of government anti-fraud efforts. He also talked about DOJ's commitment to defending and continuing to defend the constitutionality of the FCA's QTAM provisions. We're going to talk about that constitutional question as we go forward here. He talked about the growing circuit split on causation standard for the anti-kickback statute as it relates to the False Claims Act. That's another thing we're going to talk about today. So in some ways, Michael Granston's remarks serve as a useful roadmap for our discussion today. Included at the conference, not only by Michael Granston, but other members of civil frauds and DOJ Civil Division and others, was a discussion of priorities. And just to talk briefly about this, healthcare we'll get into later on. We can talk in more detail. We've already talked about pandemic fraud. Customs and tariff evasion is an interesting area. That's something that's certainly been in the news. In the remarks about that issue, DOJ officials mentioned a focus on country of origin, the declared value of goods, and the number of goods involved. And the example provided was a 2023 settlement involving a vitamin importer that imported from China, misclassifying its products to avoid paying customs duties. And these types of cases, particularly as we move forward here and as tariffs continue to be rolled out, if and when they are rolled out, really create prime candidates for a reverse False Claims Act theory where importers and others owe the government money, and you very well may see DOJ looking to crack down on that and initiate enforcement activity. The other priority listed there at the bottom is cybersecurity, and this has to do with government contracts, including at DOD that include provisions about taking steps to increase cybersecurity. And you can imagine how that would give rise to a False Claims Act claim if appropriate precautions are not made. Certifications are nevertheless made about compliance with those requirements, and federal funds are paid. So again, this was a really useful initial discussion from career officials at the department, but also that gave us some idea of how the new administration was going to proceed. So with that, I'm going to turn it over to Tanner because most of what we're talking about today is about how the new administration has continued, again, fairly aggressive FCA enforcement. But we want to talk about one area where there's been a little bit of a rollback consistent with prior Republican administrations. And with that, I'll go ahead and turn it over to Tanner.
Yeah, thanks, Abe. So now we're going to turn to some developments as it relates to what's called sub-regulatory guidance and how that guidance impacts FCA enforcement. Sub-regulatory guidance is agency guidance that is issued outside of the notice and comment rulemaking process. This sort of guidance is common across all agencies, and DOJ is certainly no exception. Sub-regulatory guidance has been something of a hot topic in enforcement matters for coming up on a decade. So by way of background, in 2017, then Attorney General Jeff Sessions issued a memorandum explaining that the DOJ's guidance documents should not be interpreted to create any substantive rights or obligations on persons or entities outside of the executive branch. This memorandum represented a growing concern within the administration over potential administrative overreach by administrative agencies. The Sessions memo was then strengthened less than a year later with the Brand memo issued by then Associate Attorney General Rachel Brand. The Brand memo went even a step farther than the Sessions memo. So whereas the Sessions memo just said that DOJ's guidance wasn't binding on outside parties, the Brand memo said that the Sessions memo should really apply to all other agencies' guidance documents, not just DOJ's. So to give an example, if DOJ employees were investigating alleged violations of FDA labeling requirements or CMS billing guidelines, the Brand memo says that those agencies' guidance documents should not be given automatic weight. Instead, DOJ should recognize that those guidance documents bind only the agencies themselves and are, at best, helpful metrics in construing the underlying statutes or the binding regulations. But then in 2021, things changed, right? We had a new administration, and then Attorney General Merrick Garland announced that he was rescinding both the Sessions memo and the Brand memo. So 3 years after the Brand memo, we get a total 180, and we return to sub-regulatory guidance being a viable basis for civil enforcement. And then sure enough, fast forward to the present, we again have a change in administration, and current Attorney General Pam Bondi has made it one of her first tasks to effectively reinstate these Sessions and Brand memos. So now we're back to sub-regulatory guidance not really being a viable basis for civil enforcement actions, at least coming from DOJ. And one thing that's particularly noteworthy about the Bondi memo is really how forcefully she goes after guidance documents in general. She states that they violate the law when they are issued outside the proper rulemaking process, yet purport to create rights and obligations. So this language suggests DOJ is going to maintain a strong stance on the use of sub-regulatory guidance in civil enforcement matters. And it will be interesting to see over the next few years whether or not there's a noticeable change in DOJ's enforcement statistics or its pronounced priorities as a result of this stance. And so keeping with enforcement priorities, I'm going to turn it back over to Abe to cover some of the things that DOJ is currently prioritizing at the moment in the FCA sphere. Oh, Abe, you might be muted there.
Thanks, Tanner. I knew I shouldn't have hit mute in the first place. So as Tanner said, now we want to turn to some of the administration's enforcement priorities. We've talked about a few already. Tariff and custom evasion is one, cybersecurity another. Pandemic fraud is a third that we've mentioned that may be impacting the statistics pretty significantly. But one major area of focus for the administration and Attorney General Bondi in particular is the opioid crisis. She has emphasized, starting with her confirmation hearing and continuing on in her public statements, that she is committed to making America safe again, including by focusing on the opioid crisis and some activity from DOJ and law enforcement more generally related to opioids focuses on fentanyl seizures, immigration-related efforts, and other similar efforts, particularly in the criminal context. But it can impact the False Claims Act as well. And we saw a few cases late last year and then into this year that are continuing on now. One has settled, but one case is continuing that give us some idea about how the administration might use the False Claims Act going forward to combat opioid addiction and the crisis more generally. So there was a settlement earlier this year involving Walgreens. We'll talk about that in a second. And then there was a case filed at the end of last year that it remains ongoing against CVS. And these are significant Controlled Substances Act and False Claims Act matters. I will say just one quick thing here, more information on this topic. Our colleague, Jonathan Porter, has a fantastic podcast, Husch Blackwell's False Claims Act Insights podcast. And I had the chance to be on with him and talk about these cases recently. But Jonathan has a whole lot of episodes that have nothing to do with me or Tanner. Tanner's been on a bunch too. But it's really a fantastic podcast. And if you're not listening to it already, I highly encourage you to do so. It just gives a lot of great information about what is going on in this space. So let's talk about the two cases we saw this year. So again, the first one has to do with a settlement that came down in the spring with Walgreens. This had to do with where the government filed a complaint and intervention earlier this year. They subsequently amended, and the complaint consolidated 4 separate key TAM cases, one of which was filed during the first Trump administration. 3 were filed during the Biden administration. At the end of the day, it was a $300 million settlement, which is obviously significant, and it's based on Walgreens' ability to pay. So Walgreens will owe an additional $50 million if the company is sold or merged or transferred prior to fiscal year 2032. And I'll get into the allegations in a second. But briefly, the other case has to do with CVS. It was filed at the end of last year, and it's pending in the District of Rhode Island. The parties are currently briefing a motion to dismiss the vast majority of the violations alleged, and we'll see how that plays out. But I want to get into the allegations here because they demonstrate how the False Claims Act can be used as a tool as it relates to the opioid crisis. So the allegation was that pharmacies filled unlawful prescriptions for opioids and other controlled substances in violation both of the Controlled Substances Act, which provides for penalties in its own right, but then also sought payment in violation of the False Claims Act, giving rise to treble damages and penalties under that significant enforcement regime. And the allegation is that pharmacists and ultimately pharmacies missed some red flags related to opioids. So to give you an example of some of the red flags that were allegedly missed as identified in the complaint: excessive quantities of opioid prescriptions filled significantly early, and particularly dangerous drug combinations. The allegations talk in particular about a combination known as the Trinity that can be particularly lethal. But really what set these cases apart, I think, is the allegation that corporate policies really drove the violations of the Controlled Substances Act and the False Claims Act. And how the complaints got there is by alleging that the pharmacies based compensation on the number of filled prescriptions, customer satisfaction surveys that otherwise pressured pharmacists to fill prescriptions quickly. And, sort of the context there is thinking about a pharmacist and what a pharmacist's role is, not just to fill a prescription prescribed by a physician, but to really take a close look and determine whether the prescription is valid or not. And so these were and are very significant cases in this space. And again, give us a sense of how the new administration, even though these cases started before, they do give us a sense of what might be in store going forward as it relates to the opioid crisis. I want to talk about a couple more enforcement priorities that we've been able to glean from memoranda and other public statements from the department. And we'll just go in chronological order. So one is gender affirming care. This has to do with a memo issued by General Bondi on April 22nd, 2025. And you'll see here that portions of the memo and the relevant portions of the memo are pasted on this slide. And the memo is publicly available, and I certainly encourage you to read it. But to give you a high-level summary, the memo is titled, quote, "Preventing the Mutilation of American Children," close quote. And what it does is it directs the Civil Division's fraud section. They're the folks who handle a False Claims Act case out of Main Justice in D.C. It directs them to pursue FCA investigations related to claims submitted to federal healthcare programs like Medicare for what the memo calls radical gender experimentation. And to give you some examples that are provided in the memo, they would include prescribing puberty blockers for an illegitimate reason. The memo explains that an example of an illegitimate reason in the memo's view, would be gender dysphoria, as opposed to a legitimate purpose, as the memo refers to it, which would be, for example, early onset puberty. So those are some of the examples and some of the parameters the memo identifies. The memo also identifies surgical procedures related to gender transition. And the memo expresses DOJ's eagerness to work with qui tam whistleblowers. This is an interesting angle. You know, one thing, and we'll get into this in a second, is I mentioned just briefly off the top, Michael Granston is no longer at the department. He was the author of the memo about critically how DOJ thinks about and how DOJ has approached in the past dismissing qui tams, particularly over the objection of the relator. And I think many of us wonder, with his departure, will there be a renewed or focus or willingness to dismiss qui tams? But at least in this memo, again, DOJ expresses its eagerness to work with qui tam relators and whistleblowers, and understands that that's a key component of this statute and its enforcement regime. There's just one more link here on the bottom of the slide, and this will take you to a rather terse press release issued just last week on this issue. And what it indicates is that DOJ sent more than 20 subpoenas to what it called doctors and clinics involved in performing transgender medical procedures on children. And it's very unusual for the department to announce the issuance of subpoenas. So this drew attention for a number of reasons. It's unclear exactly what the government is investigating. The statement in the press release said that the department's investigations include healthcare fraud, false statements, and more. Unclear if this is a criminal, civil investigation involving the False Claims Act, or all of the above. But in any event, the press release, I think, caught a lot of attention, justifiably so, and reinforces that this clearly is a priority for the administration. I want to go through just a couple more enforcement priorities here, moving ahead chronologically. And someone asked about this in the comments, so this is good timing. But Deputy Attorney General Todd Blanche issued a memorandum on May 19th, 2025. It's called the Civil Rights Fraud Initiative. Again, publicly available and accessible. What it says is that FCA liability may result when a federal contractor or a recipient of federal funds knowingly violates civil rights laws and then falsely certifies compliance. And the memo provided multiple examples, a couple here on the slide: universities allegedly encouraging anti-Semitism or implementing DEI programs. But the memo also goes into how this initiative will be structured. And the initiative is going to be co-led by the Civil Rights Division, as well as the Civil Division's fraud section, what we in this space call civil frauds. They again are the main component at Main Justice in DC that handles these cases in conjunction with the U.S. Attorney's offices nationwide. And the memorandum also specifies that each U.S. Attorney's office will identify an AUSA to advance these efforts. So this also drew a lot of press coverage, and justifiably so. And we'll have to see how it plays out. Obviously, Harvard has been in the news quite a bit in terms of research funding and so forth. And we'll have to be on the lookout for how this develops in terms of False Claims Act liability as well. So then moving forward, closer to where we are today, and actually only a couple weeks ago, is the DOJ focus on healthcare. And this had been kind of rumored or bandied about by attorneys who work on False Claims Act cases, who have white-collar practices. There have been discussions apparently within DOJ for some time during this new administration, this early part here, the first 6 months or so, about reallocating resources from certain sections over to healthcare. I think that would include potentially from antitrust to a healthcare focus. That's on the criminal healthcare fraud side, but these were interesting discussions. And so this new initiative, which relates to the False Claims Act, is in line with what a lot of us have been hearing for some time. But on July 2nd, DOJ and Health and Human Services announced that they were forming a joint False Claims Act working group aimed at strengthening their ongoing collaboration to advance certain priority enforcement areas under the False Claims Act. And we'll get to those in a second. But the membership is DOJ's civil division. I think that the civil fraud section would be taking the lead there. A couple different components within Health and Human Services, HHS. So they have a general counsel's office, which is OGC. And then the Office of the Inspector General has its own counsel. And so they would be involved as well. And then the CMS Center for Program Integrity has membership in this initiative too. And what the announcement specified, and you can take a look at the link here at the bottom of the slide, is that the working group is going to emphasize cross-agency collaboration between HHS and DOJ and others as well, and consider a few things, which are pretty interesting. The first one is payment suspensions. This perked up the ears of a lot of folks in the space because payment suspensions are not used frequently in False Claims Act cases. That was certainly my experience as an AUSA. Basically, how this works is it allows the government to kind of turn off the faucet, so to speak, on payment while it investigates an issue. And the government has a lot of discretion and a lot of leeway in doing this. And there's very limited judicial or other review options. Now, sometimes you see this, in the context of embezzlement or criminal healthcare fraud cases where there is significant evidence. People have been charged already and so forth. And the idea is let's put a stop to this and stop the bleeding. It is less common in False Claims Act investigations that are considered to be and fall into more of a gray area or have what a lot of people would consider to be less robust predication. And so the idea that DOJ and HHS are considering potentially expanding the use of this tool is concerning and interesting. It can have massive business consequences for healthcare providers. A lot of healthcare providers, hospice providers, for example, rely significantly on federal healthcare programs for their funds. And so turning off payment while an investigation proceeds is no small matter. For more on this, I plugged it earlier, really would encourage everyone to go ahead and take a listen to Jonathan Porter's podcast, False Claims Act Insights. There was a whole episode on payment suspensions, and it was terrific. So listen in for more detail there. The second item where there's going to be cross-agency collaboration and discussion has to do with the use of DOJ authority to dismiss key TAMs. And this is a very interesting issue and kind of combines a couple things we've talked about already. So as I mentioned, Michael Granston, recent retiree of the department, recent departure, he was there for some time and was really an institution in the commercial litigation branch as Deputy Assistant AG. He wrote the memo, wrote the Bible, so to speak, on the circumstances in which DOJ will dismiss key TAMs. And that's something as defense lawyers, we are very interested in here at Husch Blackwell, but everyone else should be interested as well. And I know DOJ is too. He has been replaced by Deputy Assistant AG Brenna Jenny, who comes from a firm background to this current role, although she does have experience with DOJ as well. And so it will be interesting to see how this plays out and whether there is a change or more of a willingness on the part of DOJ to dismiss key TAMs. Certainly, as I noted at the outset, the statistics indicate that the number of key TAMs is through the roof, and how that impacts DOJ's calculus going forward in terms of using this dismissal tool is something to keep a very close eye on going forward. Last slide here on this, and then I'll turn it back over to Tanner, but the working group identified some priority areas that it is going to focus on through its cross-agency collaboration. And I'll let you look at this and review the release as well, but just a couple comments here that I think are interesting. Some of these are continuations or evolutions of long-standing priority areas like Medicare Advantage, kickback schemes. Certainly that has long been a focus of the department. Tanner is going to talk about some nuances on kickbacks in a few minutes, but others are more noteworthy. And one that stands out here is barriers to patient access, third bullet down, including violation of network adequacy requirements. That's not something where DOJ has focused in terms of using the False Claims Act that much before. And so it's really interesting that it ends up on this list. But key takeaway is that healthcare has long been a priority and made up the bulk of recoveries under the False Claims Act. Clearly, this new administration is making healthcare a priority too. And it's also bringing in its own priorities and policy preferences as well. So with that, those are the priority areas in terms of enforcement that we wanted to talk about for now. Obviously, more will develop as we proceed. But for now, I want to turn it back over to Tanner for a discussion of Supreme Court jurisprudence and then some developing case law as well.
Yeah, thanks, Abe. And really interesting point on the new priorities from DOJ. And so since it got brought up in the chat, I'll address it here just briefly. So one thing that I think will be a tricky thing for courts and litigants to grapple with some of these new priorities, especially on the higher ed side of things, is whether or not these new priorities, if compliance with them is actually material to the government's payment decision. So for those of you who practice in this sphere a lot, you know that in order for there to be an actionable false claim, the violation, right, the misstatement has to go to a contract provision or a statute or regulation, compliance with which is material to the government's payment decision. And courts have really kind of whittled materiality down to three factors. One is express condition of payment, right? Does the government say that you must comply with this in order to get payment from us? Whether or not the regulation or the statute goes to the essence of the bargain, is it an absolutely mission critical part of what the government's trying to do? And the third is the government's prior actions, right? Does it typically pay these claims even though defendants or contractors are violating that provision or regulation? Does the government bring enforcement actions regularly? And at the moment, especially when we look at kind of the way the higher ed changes have been couched by DOJ, there's not really an enforcement history that we can look at because this is so new. So when we go to that third factor of the government's prior actions, we're kind of operating in the blind here. So it's going to be very interesting to see what litigants and the courts do with that. So anyways, I hope that's responsive to the question in the chat there. Certainly happy to provide more thoughts on that as we go on here. But returning to the slides, we're now going to talk about some recent developments in the case law. Earlier this year, the Supreme Court issued its first FCA decision of 2025 in a case called United States ex rel. Heath v. Wisconsin Bell. This case was interesting because it dealt with the precise meaning of the term claim under the FCA. And you would think with a statute called the False Claims Act, the meaning of the term claim would be pretty well settled, but it turns out that wasn't exactly the case. So Wisconsin Bell dealt with a unique regulatory program established by the FCC called the E-rate program. The point of this program was to ensure universal access to telecommunication services for schools and libraries. And notably, this program was funded entirely by statutorily required contributions and was administered by a private nonprofit corporation. The relator, Wisconsin Bell, accused the defendant of submitting false claims for reimbursement under the E-rate program. But the parties sharply disagreed over whether these reimbursement requests could even be false claims at all for FCA purposes, right? Remember that false claims typically involve claims which are for government dollars and which are presented to government actors. So here, the defendant argued that its reimbursement requests couldn't trigger FCA liability because, first of all, the program was privately funded through statutorily required contributions. And second, the program was administered by a private entity. And then the relator, by contrast, and supported by the government, argued that the requests could trigger liability because a portion of the funds actually did pass through the U.S. Treasury at some point, even though they began in private hands. and because the program administrator was essentially an agent of the government. And the Supreme Court took the path of least resistance here. In a unanimous ruling, the court held that because the government contributed around $100 million in funds to the program via collections of delinquent contributions and recoveries by the Justice Department, that was enough to make the requests at issue claims for FCA purposes. Now, as often happens with Supreme Court rulings, what the Supreme Court did not hold is arguably more interesting than what it did hold. So as Justice Thomas noted in his concurrence, the court did not rule on two more challenging questions. First, whether the fact that the government requires companies to pay into the fund means that the government effectively, quote, provides those funds. And second, whether the E-rate program administrator is an agent of the government. So the court didn't take up those questions, even though they are kind of meatier questions that really seem to have a bigger impact on the FCA landscape. So while Wisconsin Bell's holding itself has really little impact on the FCA world outside of the specific context of the E-rate program, there's lots of potential litigation to be had on those two unanswered questions, right? For example, courts have long struggled with the question of whether payments owed to Medicaid managed care or Medicare Advantage organizations constitute false claims, given that those entities are private. So until we get an answer from the Supreme Court on the second question that Justice Thomas highlighted, this struggle is going to persist. Another lingering question that Wisconsin Bell posed was whether the FCA's key TAM provisions are even constitutional at all. This has been a recurring theme. So in his concurrence, Justice Kavanaugh, joined by Justice Thomas, raised concerns over the constitutionality of the key TAM provisions and encouraged the court to consider the issue in an appropriate case. Now, that may sound familiar to some of you, since Justice Thomas raised that same issue in a dissent about 2 years ago. That dissent was joined by Justices Kavanaugh and Barrett. Interestingly, Justice Barrett did not join in Justice Kavanaugh's concurrence this time around. Who's to say why she didn't do that? It's possible she doesn't feel that this is an issue that should be brought up. It's possible that she already made her views known and didn't feel the need to repeat herself. So it's not totally clear, but all of that stemmed from, like I said, Justice Thomas's dissent in a case back in 2023. And so now Abe is going to walk us through that dissent and what's come out of the case law since then.
Thanks, Tanner. Yeah, so this case called Polanski is really the origin of these questions about the constitutionality of the FCA's key TAM provisions. And Polanski had to do, in the main, with whether the United States, if it declines to intervene in a case, in a False Claims Act case, can subsequently intervene in the case and dismiss the case, and if so, what standard applies. And so, very interesting case for that reason. But in a dissenting opinion, Justice Thomas discussed significant reservations he has about the constitutionality of the FCA's key TAM provisions, given the significant role of the relator in litigation on behalf of the United States, and particularly in decline cases, the amount of control that the relator can exercise over the litigation and crucial litigation decisions. And in his dissenting opinion here back in 2023, Justice Thomas noted that Article 2 of the Constitution, in his view, vests executive power in the president alone. In other words, going along with what a lot of us have heard referred to as the unitary executive theory, that the president really personifies the executive branch. And so stemming from that principle is the idea that vindicating public rights, like in a False Claims Act lawsuit, is a task for executive officers under the president's control who are appointed pursuant to the Appointments Clause. The Appointments Clause has kind of a two-tiered structure. Certain officers have to be nominated by the president, confirmed by the Senate. Inferior officers, or so-called inferior officers, can have their appointment vested in the president alone, an agency or a court. But again, they cannot appoint themselves. And so in Justice Thomas's view, a private relator has not been appointed as an officer of the United States in compliance with and in accordance with the Appointments Clause. And so his conclusion is that there is good reason to suspect that Article 2 does not permit private relators to represent the United States interests in False Claims Act suits. And Justice Kavanaugh wrote separately in that case, concurring. He was joined by Justice Barrett, and he agreed, as Tanner mentioned, that the court should consider the competing arguments on the Article 2 issue. So that was how this started a couple years ago. And then things have only gotten more interesting since. So last fall, in United States ex rel. Zafarov, a case coming out of the Middle District of Florida, the judge granted judgment on the pleadings based on a constitutional challenge to the False Claims Act's qui tam provisions. And the decision was issued by Judge Catherine Kimball Mizell, who is actually a former law clerk to Justice Thomas. And she very much picked up on his opinion in Polanski to find that the qui tam provisions are unconstitutional. And she relied on the Appointments Clause, again, which is what we just walked through. That was Justice Thomas's primary concern there. And here's kind of how she delineates the argument. So she found that a relator is an officer of the United States and thus needs to be appointed pursuant to the Appointments Clause. Obviously, a relator is not appointed in that way. It's really self-selection. The relator decides to be a whistleblower, file a complaint under seal, and if take part in the litigation no matter what, and if the United States declines, really take charge of the litigation and take a lead role. One big argument was that the qui tam device goes way back to the founding generation and beyond. And in this case, in Zafarov, the judge found that historical examples do not exempt an FCA relator from the Appointments Clause. She also found that dismissal is the only permissible remedy and granted judgment on the pleadings and dismissed the case. There was another constitutionality argument raised in that case about the vesting clause and the take care clause of Article 2. And she relied on the Appointments Clause to find the FCA's qui tam provisions unconstitutional. And because of that, and because of her finding, she did not address the vesting and take care clause arguments there. So this case is on appeal with the 11th Circuit. It is fully briefed as of this morning when I checked. Argument has not been scheduled, but needless to say, a lot of us in this space are watching very closely to see if an appellate court will get on board with this argument such that this case could percolate up to the Supreme Court. And it's a very interesting question about how this would play out in front of the Supreme Court. I don't want to get too far ahead of us, but we have some idea already because, as Tanner mentioned earlier this year in the Wisconsin Bell case, Justice Thomas again reiterated the constitutional concerns he has, as did Justice Kavanaugh. As Tanner mentioned, notably, Justice Barrett did not join Justice Kavanaugh's comments on the constitutionality question. And so it's unclear what's going on there and whether that means that she would join or not join an opinion finding the FCA's qui tam provisions unconstitutional if that question were presented to the court. It's a very interesting question. But also this spring, we got the first, at least U.S. Court of Appeals appellate judge buy-in on these constitutional arguments. And this was in a case out of the Fifth Circuit from Judge Duncan. He was constrained by Fifth Circuit precedent, which some circuits have already addressed this constitutional issue before Zafarov, before Polanski, and had circuit precedent that kind of binds the hands of judges in the circuit. But he wrote separately to point out the constitutional flaws, in his view, in the FCA's qui tam device. And unlike the Zafarov case, he made a two-pronged argument. He talked about the Appointments Clause and the Take Care Clause. And so this was a very interesting development to see a Court of Appeals judge weigh in on this issue and seemingly encourage, implicitly the Fifth Circuit to reconsider their position through en banc review, that, which has not happened in this case, but is something to keep an eye on, and obviously all the more reason to keep an eye on and follow closely the 11th Circuit consideration of Zafarov. So that's constitutionality, very interesting. There's another issue going on right now that's developing, and Tanner's going to tell you more about that.
Yeah, thanks, Abe. And a couple more points on the constitutionality, just some interesting things to add to the confusion. So the Fifth Circuit, a panel of the Fifth Circuit back in the late 90s had actually found the qui tam provisions unconstitutional. A case, I want to say it was Riley v. St. Luke's. I could be getting that wrong, but then the court took that issue en banc and reversed the panel. So the Fifth Circuit has had an en banc ruling on this a couple decades ago, and now you have members of the Fifth Circuit saying we need to go back and look at that again. And so you're seeing that kind of across the country where, this question was previously settled, or it was settled as to one of the clauses but not the other, and there's this renewed interest in taking up these issues. So like Abe said, it'll be very interesting to see what other courts of appeals do with this. I mean, defendants are certainly going to keep raising it until it's established one way or the other by the Supreme Court. So moving on to another interesting development in the case law, we're going to talk about an emerging circuit split as it relates to FCA liability for violations of the anti-kickback statute. The anti-kickback statute, for those of you who don't know, is a criminal law that prohibits the knowing and willful payment of remuneration to induce or reward patient referrals or the generation of business involving any item or service payable by the federal healthcare program. So, for example, drugs, medical supplies, healthcare services for Medicare or Medicaid patients, that's all encompassed by this act. In 2010, Congress amended the anti-kickback statute to specify that a claim that includes items or services resulting from a violation of this section constitutes a false or fraudulent claim for purposes of the FCA. And you'll see I italicized resulting from, because that's what's really driving this current circuit split. So on the one hand, we've got the minority view of this split. Right? There are two prevailing views at the moment. The first is this minority view, which has been endorsed only by the Third Circuit. And under that view, a claim results from a violation of the anti-kickback statute, even if the violation did not actually cause the government to pay the claim. So in the minority view, all that's required is for there to be some link between the anti-kickback statute violation and the ultimate payment of the claim. And so, as I said, only the Third Circuit has endorsed this view. And to give the Third Circuit a break, at the time of its decision, this was an open question. No court of appeals had addressed it. So it was sort of paving the way and didn't have the benefit of more developed briefing and case law on the issue. So that's the current view in the Third Circuit. And then we get the majority view, and it's the clear majority view at this point. It's been endorsed by the First, Sixth, and Eighth Circuits. And this view requires the violation of the anti-kickback statute to be the but-for cause of the government's payment of the claim. So for all the lawyers on the webcast here, if you think back to 1L torts, a but-for cause is a cause in fact of the ultimate act. And the primary reason that courts seem to be trending toward this majority view as it relates to the anti-kickback statute is really a concern that without some sort of but-for or actual causation limitation, the FCA would simply stretch too far. It would swallow up conduct that the FCA was never intended to prescribe. And this is really in keeping with a lot of comments that we've seen in the FCA case law for about the past decade or so. If we think back to the Supreme Court's decision in 2016 in Universal Health Services, Inc., v. United States, ex rel. Escobar, the focus was really on, does this matter to the government? Is this actually going to be something that impacts the government's payment decisions? So this is kind of another side of that same coin. And so now closing it out here, we're going to move on to the last slide of the day, which highlights a couple recent district court cases interpreting the resulting from language in circuits where the Court of Appeals hasn't yet spoken on this issue. So the first one is Wilkerson. This was a decision out of the Northern District of Illinois. And the judge in that case adopted the but-for standard, the majority view, for a couple of reasons. One, because it was the majority view, so there was a lot of case law supporting it. But also more significantly, the judge felt that the majority view better aligned with the Seventh Circuit's reading of other analogous statutes. So this was essentially the district judge kind of predicting how the Seventh Circuit would rule on this issue if given the opportunity. So that provides some really interesting fodder for defendants who are within that circuit to say, hey, another judge in this circuit has looked at this, and this is what they've predicted. The second case, the Schroeder case, is interesting because it proceeds essentially parallel to the developing circuit split. Schroeder was out of the District of Kansas, which is part of the 10th Circuit, and the 10th Circuit has not taken a position on how to properly interpret the resulting from language. So earlier in the case, the district court was faced with this question of how to interpret it, and it followed the minority view, the one endorsed by the Third Circuit. But at that time, the minority view was the only view out there. No other court of appeals had ruled on this issue. So later in the case, the parties relitigated this issue in light of the developments of the case law, and the district court struggled a bit with what to do and essentially punted. The court noted that the outcome would be the same under either standard, and so it wasn't going to revisit its prior holding. And I think this struggle in Schroeder provides a useful example of how courts in circuits other than the First, Third, Sixth, and Eighth might grapple with the statutory language. I think we can expect to see more district court opinions of this sort and potentially some deepening of the circuit split as other courts of appeals weigh in. So, of course, as with a lot of what we've discussed today, we won't get any real certainty on a nationwide scale until the Supreme Court provides its definitive view. And so that covers everything for today. I'm going to pass it off to Abe for some closing remarks.
Thanks so much, Tanner. We've really enjoyed this. Thank you so much for joining. If you have any questions in the next couple minutes, feel free to throw them in the chat. We'll answer them. And if not, as Tanner said, we can follow up via email. And feel free to follow up with us as well. But overall, thank you for joining us today. We hope this has been helpful to you and your organization. Just a couple of reminders before we sign off here. This program has been approved for legal education hours. And to report your hours, click on the Continuing Education sign-in button at the top of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And be sure to complete our short survey if you have a chance to do that. We'd really appreciate it. We certainly use your feedback to plan future programs that are applicable to your business needs. And we would appreciate it if you take the time to do that if it fits with your schedule. So this concludes our webinar. Thank you very much, and we'll see you next time.